Hi everybody, welcome to the 11th video for Legal Studies 3-4. In today's video, we're going to be looking at the role of courts through precedent, statutory interpretation, and finally factors that affect the ability of courts. So to start off with, looking at precedents. So the doctrine of precedent operates where judges in superior courts create common law through making landmark decisions and interpreting statutes where no other principle exists and there's no principle for that judge to follow. So once that judge creates common law, that decision forms a legal principle which all judges in lower courts are bound to follow, which is what we call a binding precedent. Judges in higher courts may be persuaded and influenced to follow a principle by a lower court, but they can choose whether they want to do so. And that's what we call a persuasive precedent. Precedents create consistency and predictability in the law, as similar cases are being decided in the same way and having the same legal principles applied to them. The doctrine of precedent upholds the principle of stare decisis, which is Latin for let the decision stand. There are two different types of precedents. The first type is the ratio decidendi, which is the legal reasoning for the judge's decision, which is binding on all lower courts. However, the obiter dictum is comments made by the judge, which are not the specific reasons, but a consideration that the judge took into account, and they are only persuasive, so judges can choose whether to follow them or not. Decisions of courts in another hierarchy, such as interstate or international, are only persuasive. An example of the doctrine of precedent and its operation is Donoghue versus Stevenson, and the Grant and Australian Knitting Mills cases. So in Donoghue and Stevenson, it was a UK case where a woman bought a bottle of ginger beer and she drank it. And after drinking it, she saw that there was a decomposed snail at the bottom of the bottle. So she became sick and she decided to sue the manufacturer for negligence because there was no way that the shop owner was at fault. It was a sealed bottle and it was opaque, so I had no way of knowing it. In Donoghue versus Stevenson, the court decided that when a manufacturer sells a product, which they know will reach a consumer, and where inspection of that product is not possible by the customer, so for in this instance where it was an opaque bottle, the manufacturer owes a duty of care to the consumer and must take reasonable steps to avoid harm. And that was the first English case to establish this kind of principle of manufacturer's liability and in the law of negligence. In the Australian case of Grant and Australian Knitting Mills, a man bought a pair of underpants and developed dermatitis, a rash, because the pants had chemical residue. It was not the shop's fault, and similar to Donoghue versus Stevenson, you could not see the defective product because the chemical residue was invisible. And so the courts used the principle of Donoghue versus Stevenson and confirmed that the manufacturer was liable. So these are some instances in which the courts can avoid using precedents. So one way is by distinguishing the case. So this is where the lower court is usually bound to follow the principle, but they can avoid using it by stating that the present case has materially different facts to the facts of the case in the precedent. So they're no longer bound. So if one case was about products where you can't see the defect, and in this case it was a product where you could see the defect, then maybe Donoghue versus Stevenson would not apply. Reversing is where a higher court changed the decision of a lower court in the same case on appeal. So if the parties are dissatisfied with the outcome, they appeal it to a judge in a higher court who then changes that original decision of the lower court. Overruling is where a higher court judge changes a precedent established in a lower court in a different case at a later date. So it's not an appeal, it's a totally different case, which has similar facts, but the judge decides that precedent set in a previous case is no longer valid. And finally, disapproving is where a lower court is bound by a precedent, but they express their dissatisfaction with the precedent and hope that a judge in a higher court or parliament would overrule and change that precedent at a later date. So ultimately, the judge is still bound to follow that precedent in that case. Next, we move on to statutory interpretation. So we looked at statutory interpretation in regards to the High Court and its ability to interpret the Constitution. And it has the same meaning here. So it's where judges give meaning to the acts of the Parliament and their interpretation forms precedent. So it's binding on all other lower courts when they are interpreting the same statute. The reasons why statutory interpretation may be necessary is if there's a mistake in the Act of Parliament, or if the Act is ambiguous or inconsistent, so it might use high schools in one place, primary schools in another place, and then say schools in another place. Does that mean all schools, or do they make a mistake? And the judges would have to interpret that and decide. Also, new technology may have been created since the Act was written. So the technology may refer to cameras and phones, but does that also apply to drones, which weren't, created at the time that the Act was created? Also, the meaning of words may change over time, which may mean the Act no longer makes sense, or the Act is drafted really, really broadly, and the judges need to interpret whether a specific situation falls under that broad definition or not. Through judges' interpretation, they will either broaden or narrow the application of the Act. So, for example, with that schools example, if it said high schools in one place, primary schools in another place, and schools in another, the judge could interpret schools as all schools and broaden the application of that to mean all schools, or it could narrow the application of that Act by interpreting it to mean primary schools, and it would only apply to primary school students. An example of statutory interpretation being used is the case of Dean in Tarola. So a man was wearing a studded belt and he was charged under the Control of Weapons Act for being in possession of a weapon. And the magistrate found him guilty and they confiscated the weapon. He appealed his decision and the Supreme Court judge defined the term regulated weapon. And the Supreme Court judge determined that a regulated weapon was only something that could use to inflict harm and injury. And so they interpreted regulated weapon, made that definition, and that definition then forms a precedent for all other judges to follow when interpreting that section. And so because it could only be something only used to inflict injury, the man could not be charged under this Act because a belt is also an article of clothing. Next, we move on to the factors that affect the ability of courts to make law. So looking at the doctrine of precedent, the doctrine of precedent enhances the ability of courts to make law because it creates consistency and predictability for the law in that similar cases are applied, the law is applied to similar cases in the same way. And that also provides judges with some guidance to ensure that they are correctly applying the law to the case before them. And more importantly, the doctrine of precedent saves court resources because the same legal issues aren't being decided again and again and again. However, the doctrine of precedent limits the ability of judges to make law if they are bound by a precedent. And that also may mean that the quality of the law is reduced if a judge is bound by an outdated precedent, which has undesirable implications. And then also the fact that judges have to wait for a case to be brought before them, and they have to wait for a person with standing to initiate a case. So judges have very limited scope to actually make decisions when you put those things together in addition to the doctrine of precedent. So we talked about in area study 1 and 2 the costs involved in initiating a claim. Such costs actually impact the courts in a positive way because they deter baseless claims from being introduced into the court system. Essentially cases that have no merit and no actual legal arguments. And so it saves court resources from being wasted on those cases. Also remember that costs involved in court encourage out-of-court settlement, which is beneficial for parties. Costs, however, may discourage parties from initiating a claim in court and therefore reduce the ability of courts to make law. Parties may also therefore go to VCAT or CAB or another dispute resolution body, which don't actually create precedent. And so it reduces the ability of courts to make law in that way as well. Next, looking at standing. So remember that standing is where only people who have been genuinely affected by legal issues of a case can initiate a claim in court. And so that is beneficial because it ensures that court resources are not wasted. However, it prevents those from having bringing a claim for the common good of society or bringing a claim on behalf of disadvantaged groups who may not have otherwise been able to afford a case. And so that means that potential improvements to the law may be restricted. Next, we look at judicial conservatism. So judicial conservatism is a theory of thought that judges use when applying the law and interpreting cases. So judicial conservatism is where judges are reluctant to create precedent and change the meaning of the legislation beyond its literal meaning, because they see themselves as an enforcer of the law and an interpreter of the law, not a lawmaker. So judges do not go beyond the literal meaning of words when interpreting legislation. This is good because it maintains consistency and predictability in the law. There's very little change and the law is stable. It also upholds the separation of powers because the judges are purely enforcing and interpreting the law, and Parliament is responsible for creating the law. And that ensures that the laws are also representative because Parliament is elected. Judicial conservatism also reduces the number of appeals because the law is stable and within the community's level of comfort, and that reduces the court backlog and preserves court resources. However, judicial conservatism reduces the ability of courts to make necessary controversial changes, and it also may mean that the decisions unfairly impact individual rights because judges don't consider political and social factors in their decisions. The opposite of judicial conservatism is judicial activism. So this is where judges do consider a range of political and social issues and are more progressive and seek to uphold individual rights when making decisions. So judges using judicial activism enhance the ability of courts to make law because they allow the courts to uphold individual rights and they make significant improvements to the law. So an example of judicial activism is the Marlborough case, where the judges confirmed that native title, so Indigenous land rights. Prior to that, there was very little Indigenous recognition of sovereignty and Indigenous land rights. So the judges in Marlborough were activist judges in that case. They considered the social and political factors of Indigenous rights movements and that kind of thing, and changed the common law principles on that issue, and were able to uphold Indigenous people's rights and encourage further change down the line. However, a conservative judge would have continued with that line of previous thought, that Australia was terra nullius and that the Indigenous people had no legal right to the land. So that shows the way in which judicial activism made significant improvements to the law. However, through judicial activism, it means that judges who are not elected and representative of people are creating laws. So it's maybe seen as undermining the separation of power. And it also may mean that laws are not representative, which may mean that there are more appeals on a point of law because decisions may be outside of the community's level of comfort. So that brings us to the end of that video, and I hope to see you in the next one.